Hello, my name is Joe Facenda. I am a realtor with Remax Gateway here in Northern Virginia, just outside of Washington, D.C., and I've been a realtor here for over 30 years. In the last few years, I've made working with inherited property a specialty of mine, and in fact, I've written a book called When Parents Are Gone, What's Next with the House, and the book is available on Amazon. In this section of videos, we are discussing who controls the property, who has the right to sign applicable paperwork, and when can you get started with your plans for the property. The answer to those questions depends upon how you receive the property. In this video, we will talk about receiving the property as an heir. This means there was no will, there was no trust, and there was no transfer on death deed, all topics discussed in other videos. The answer to the questions when there is an heir involved in some ways is very simple and in some ways is very complicated. This video might be a little bit longer than the others because there are some complications that I think we need to discuss. Let's start with the real simple. Real simple would be last parent passed, you are an only child, you are obviously the only heir. Another simple situation would be last parent passed, there are 4 children, none of the children have predeceased the parents, there's been no siblings predeceasing the parents, all 4 children are in agreement as to what to do with the property. In both of those scenarios, you can move forward and start your plans for the property as soon as you want. You can contact a realtor and sign a listing agreement. You can enter into a contract with a buyer. But you cannot settle on the property until probate has been filed or you've made an appearance before the court. I say probate's been filed. There may be situations in small estates where you don't have to file probate, but you need to make an appearance before the court. And here's the reason why. The title company that's going to settle this sale transaction has one very important job, and that's to make sure that the property is being transferred legally, and that all the people who need to sign the paperwork are signing the paperwork. When an inherited property is being sold, there's no way for the title company to verify legally who all of the heirs are unless they get a document from the court, which is called a list of heirs. So you need to go, or somebody in your family needs to go before the court so that this document, list of heirs, can be produced prior to you being able to settle on the property. Now, I mentioned it's simple if all 4 of you want to sell the property, your four siblings want to sell the property and everybody's in agreement, that's great. If 3 want to sell and 1 does not want to sell, there's nothing that can be done. All heirs need to sign all documents. If you're in a situation where 3 want to go in one direction and 1 wants to go in a completely different direction, nothing can be done until that one person changes their mind, the 3 change their mind, or there's some decision made by a court. Now, the trick is determining who the heirs are in more complicated situations. A couple years ago, I had a case with 17 heirs. I thought that was a lot. Till I had the case a few months later with 87 heirs. How do you get 87 heirs? Well, you have to sort of look at the family tree and figure out who the heirs are, and it gets messy really, really fast. In this situation, it was a 90-year-old gentleman who passed. He never married and never had any children. So where do you look next? You look up to the parents. This man's 90 years old. His parents long ago passed. Where do you look next? You look next to siblings. He had 4 siblings. He was the youngest. They had all passed as well. Okay? Did any of those siblings have any children? Surprisingly, none of these 5 individuals had any children. If they had had children, then that child or those children would have all been dividing up this house. But without any siblings alive, without any nieces or nephews, next we went back up to the parents, out to the parents, brothers and sisters. Again, all of those people have passed. But here we had children still alive, we had grandchildren, and I think we might have even had a few great-grandchildren. All of a sudden, there's 87 people involved. So if you have an estate with more than 5 or 6 or 7 people, you might want to do one of 2 things in terms of how you're going to proceed with documents and signing, because each of these estates handled a little bit differently. In the situation with 17 heirs, they got together in groups of 4 or 5, and they gave power of attorney to one of the other heirs. So I had a listing agreement signed, and it needed 17 signatures, but I only had to contact 3 or 4 people because they had power of attorneys from all the others. And so every document, the contract, the listing agreement, all the settlement paperwork had to have 17 signatures, but only 3 or 4 people needed to be contacted. In the case of the 87 heirs, they actually knew of a trusted family friend of the deceased who was local to the area. None of these other 87 were even in Virginia or Maryland. They mostly were in upstate New York and Ohio. So they all agreed through their attorneys to grant the power to sell the property to one individual who was not an heir. And in that case, I had that individual sign all paperwork. And that individual, of course, wanted to make sure that they got the best price and terms for all of the various family members who had different interests, in the property. So it's very important to know who the heirs are. And it's very important that if you have siblings who have passed, or I'm talking a situation where a parent has passed and siblings have inherited the property. If there are siblings who have passed who had children, it's very important that your nieces and your nephews also sign all applicable paperwork. I hope that helps. It's very complicated. There the laws of intestate, it's called intestate when you die without a will or a trust, may vary state by state. I can tell you how it works here in Virginia, as I did with the example of the 87 heirs. I'd be happy to talk to you about your situation. I am not an attorney, but I can certainly give you advice on the questions to ask an attorney. So just reach out if there's something in your situation that you want clarification on. Okay, so next you can go to one of the other videos in this section that talk about inheriting a property via a will, via a trust, or via a transfer and death deed. But I think the next important one for you to take a look at is the video on steps to take early in the process. What things should you be doing to prevent potential legal problems down the road, and what should you be doing in certain situations to get out in front of any tax consequences? So wherever you go, I'll see you there, and we'll continue the conversation. Thank you very much for watching the video.